Natalie Fenter. I'm an associate at Otrebski Attorneys, and today I'm going to be discussing court bail applications. Now, court bail applications are applicable to three different categories of offences. That is Schedule 1, Schedule 5, and Schedule 6 of the Criminal Procedure Act. When it comes to Schedule 1 offences, these are generally dealt with on an informal basis. The offences covered by Schedule 1 are, for instance, theft of more than 20,000 Rand. It is also fraud of more than 20,000 Rand, but under 500,000 Rand. And it is also domestic violence related offences. Now, when I say that the bail application is dealt with on an informal basis, this is to say that the court will just require certain points of information which need to be given by the defense and the prosecution. Once the court is satisfied with this information, they will then set a bail amount and the accused can then be released. The exception is that domestic violence related offences are generally required to be brought on a formal basis, that is by a bail affidavit, but the court does have the discretion to dispense with this requirement. The court is also going to require that the accused person make a declaration in terms of Section 6011B of the Criminal Procedure Act. This is that they do not have any previous convictions, pending cases, outstanding warrants, or protection orders against them. Now, where an accused person does have a previous conviction of a Schedule 1 offence and they have been accused of committing a Schedule 1 offence, the offence is then classified under Schedule 5. Now, a Schedule 5 offence is an offence in terms of which a formal bail application needs to be brought. This is done by affidavit, alternatively by putting the accused person in the stand. Now, Schedule 5 offences, regardless of whether there's a previous conviction, they are, for instance, fraud of more than 500,000 Rand, sexual assault, and murder. The attorney would need to make certain declarations or would need to incorporate them into the bail affidavit, which is deposed to by the accused person. And the burden of proof is that it needs to be in the interest of justice for the accused person to be released. Provided the court believes it is in the interest of justice, a bail amount will be set, and again, it will need to be paid at court, whereafter the accused person would be released. The last category of offences is a Schedule 6 offence. These are your most serious offences in terms of which a life sentence can be imposed. This is, for instance, rape of a minor, premeditated murder, or armed robbery. The procedure here is also on a formal basis. It can be brought by bail affidavit or by putting the accused person in the stand. And the burden of proof in this instance is that there must be exceptional circumstances permitting the release of the accused. So, for instance, the accused person must have either declining health or a health condition which cannot be maintained or treated in prison. Again, once the court is satisfied that the burden of proof has been met, a bail amount will be set. It needs to be paid at court, and the accused person will then be released. Should you require any extra information with regards to court bails, please visit our website or follow us on Instagram. Thank you.